Warm greetings to one and all present. I hope everyone is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be sharing my views on the topic Relationship between Fundamental Rights and Directive Principles of State Policy, Recent Trends. Let's begin with the brief introduction. The fundamental rights are those that every citizen is expected to possess. These rights are guaranteed by the Indian Constitution, which includes the freedom of expression, freedom of religion, and the equality of all the people before the law. A series of rules known as Directive Principles of State Policy are intended to help the government advance the social and economic justice. Although not legally enforceable, they play a very crucial role in preventing the misuse of power by the government. Enshrined in Part 3 of the Constitution, the fundamental rights ensure that every citizen has the access to the most basic rights. These rights include the freedom to practice any religion, the freedom of speech and expression, the right to equality, and the right to life and liberty. Part 4 of the Constitution lays forth the objectives that the state ought to pursue in its directive principles. These values include the advancement of economic and social justice, protection of our labor rights, and of course, the conservation of natural resources. Now, let's articulate upon fundamental rights. The Indian Constitution is the first and foremost a social legal document. The majority of its provisions are either directly aimed at furthering the goals of the social revolution or attempt to foster this revolution by establishing the conditions necessary for its achievement. Fundamental rights derived their inspiration from the USA Constitution. The fundamental rights of the Indian Constitution are rightly described as the Magna Carta of Indian Constitution. These fundamental rights are justiciable and contain a very long and comprehensive list. In fact, the fundamental rights in the Indian Constitution are more elaborate than that of the other constitutions of the world. They uphold the equality of all the individuals, dignity of all the individuals, large public interest, and of course, the unity of the nation. Now, let's understand the meaning and significance of fundamental rights. Fundamental rights promote the idea of political democracy. It means they prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedom of the people against the invasion by the state. In brief, the fundamental rights aim at establishing a government of laws and not of men. The fundamental rights have been declared as essential rights in order that the human liberty may be preserved, human personality, and to be developed and effective social and democratic life be promoted. The fundamental rights are guaranteed and protected by the fundamental laws. They also play an important role for the all-round development, that is material, intellectual, moral and spiritual development of the individuals That is why these rights are named as fundamental rights. Originally, the Constitution of India provided 7 fundamental rights, namely right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, and right to constitutional remedies. Later on, right to property was deleted from the list of fundamental rights and was made a legal right under Article 300A in Part 12 of the Constitution by 44th Amendment Act 1978. Now, currently there are only 6 fundamental rights, and the fundamental rights weave a pattern of guarantee on the basic structure of the human rights and also impose a negative obligation on the state not to encroach on individual liberty in its various dimensions. Now, let us see what is the nature of fundamental rights. The fundamental rights are individual rights and are enforceable against the state and not against individuals, except right against untouchability, that is in Article 17, right against exploitation, that is in Article 23 and 24, and right to personal liberty, that is in Article 21, whereby in case of the violation, actions can be taken. Any individual who has violated these rights can be taken to the court of law. The fundamental rights are regarded as limitations on the powers of the state. They are also negative obligations upon the state because they are mostly negatively quoted that restrain the government from doing something unjust. The fundamental rights have to be exercised subject to the limitations embodied in that very part itself, that is Part 3 of the Constitution. Thus, the rights are not absolute, or you can say it is unrestricted. Absolute rights cannot exist in a modern state. If the rights are uncontrolled and absolute, it may lead to chaos and anarchy in the society. Now, the question is whether there can be suspension of fundamental rights. Article 358 of the Indian Constitution states that the fundamental rights provided under Article 19 are automatically suspended when the national emergency is proclaimed on the grounds of war and external aggression. However, if the national emergency is proclaimed on the grounds of internal armed rebellion, the rights under Article 19 are not automatically suspended. Article 359 states that the President may by order can issue proclamation to suspend all the fundamental rights mentioned in Part 3 of the Constitution except Article 20 and 21 during the national emergency situation in the whole country or in the part of the country itself. Now, let us see, are there any restrictions on the fundamental rights? The fundamental rights of an individual have been restricted under some or all of the following grounds under various articles. Let us see. Number 1, for the security of the state. Number 2, for the maintenance and promotion of the interest of women, children and the socially and educationally backward class. Number 3, to maintain friendly relations with the foreign states. Number 4, in cases of defamation. Number 5, contempt of court. And number 6, for the maintenance of public order, decency or morality. Now, let us talk about directive principles of state policy. An important feature of the Indian Constitution is the directive principles of state policy. They have been enshrined in Part 4 of the Constitution from Article 36 to 51. although the directive principles are asserted to be fundamental in the governance of the country, they are not at all legally enforceable. Dr. B.R. Ambedkar described that the directive principles of state policy are as novel features of the Indian Constitution. Granville Oyston has further described the directive principles and the fundamental rights as the conscience of the Indian Constitution. The directive principles resembles the instrument of institutions as enumerated in the Government of India Act 1935. Nature of directive principles. These are the positive obligations. The directive principles impose positive obligations on the state. The directive principles can be implemented by the executive action as long as they do not contravene any law. The instruments of the state have moral obligation to follow these directives and to act in consonance with these directives. They are non-justifiable as they expressly given in Article 37, which declares that the directive principles shall not be enforceable by any court of law. But this non-enforceable nature does not reduce the importance of directive principles, as these directives have been at the same time declared as fundamental in the governance of the country. It has been further laid down a duty of the state to apply these directive principles while making any sort of law. In the case of State of Madras versus Champakam Durai Rajan, the first important case relating to the relationship between fundamental rights and directive principles of state policy, the Supreme Court held that the directives have to conform to and run as subsidiary to the chapter on the fundamental rights. These observations of the court were based on the literal interpretation of the provisions of Article 37, which declares the directive principles non-justifiable. Subsequent to the Durai Rajan case, the Supreme Court started taking cognizance of the directive principles and relying on them. While interpreting the scope and ambit of fundamental rights, the court upheld that certain laws imposing restrictions on the rights on the ground that these laws were meant for implementing the directive principles of state policy. The term state has been defined by Article 36 to have the same fundamental meaning as is given to this in Article 12, that is in Part 3 of the Constitution relating to the fundamental rights. It thus means that the term state not only includes the legislature or the executive organs of the government, but it also includes its agencies and instrumentalities. The objective and purpose of the principles are: the roots of the directive principles may be traced back to 1931 Karachi Resolution, or further to the two streams of socialist and nationalist sentiments in India that had been following ever faster since the late 20s. The inspiration for including the directive principles in the Constitution of India is drawn from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. The objective and purpose of the principles are as follows. Number 1. The directive principles set forth the ideals and objectives to be achieved by the state for setting up India as a social welfare state, as distinguished from a mere polite state. The basic aim of the welfare state is the attainment of substantial degrees of social, economic and political equalities to provide the means whereby all its members can reach the minimum standards of economic security, civilized living, capacity to secure social status. Second objective, the directive principles are indeed the precursor to the economic, social and cultural rights as it is specified in the International Covenant on Economic, Social and Cultural Rights, that is ICESCR 1966. Third objective, they reflect the consensus on the intrinsic necessity of these means and envisage state action which would facilitate the transfer and distribution of the power, leading to transmission of power to the citizens, and this is loosely called empowerment of people. Fourth objective, the directive principles contain the social, economic, cultural and educational objective of the state. These provide a motivation for a peaceful political revolution. They provide a program for social reconstruction and economic upliftment of the people of India. Fifth objective, Article 36 provides that the meaning of state in this part of the Constitution is as the same as given in Part 3 of the Fundamental Rights. Sixth objective, Article 37 provides that the provisions of this part, that is Part 4 of the Constitution, are not enforceable in any court of law, but the principles contained in them are fundamental to the governance of the country. It will be the duty of the state to apply these principles while making any law. Seventh objective, the directive principles, though non-justiciable in nature, but it helped the courts in examining and determining the constitutional validity of a law. If a court finds that the law in question seeks to give effect to a directive principle in relation to Article 14, that is equality before law, or Article 19, that is 6 freedoms, and thus save such law from unconstitutionality. Now, let us talk about significance of directive principles. First, the directive principles has a great constitutional significance. They have been declared fundamental in the governance of country, and it shall be the duty of the state to apply these principles in making law as given in Article 37. Number 2, though these principles are non-enforceable in the courts, yet no government would dare to ignore them. Every government should take steps for implementing the directive principles of state policy as far as possible, or else it would be criticized on the ground of non-fulfillment of these directives. Number 3, these principles represent the deliberate wisdom of the nation and will act as a constant reminder to the state for its implementation. Inclusion of directive principles in the Constitution always gives a constitutional recognition of the responsibility of the state to promote social and economic welfare of the people. Number 4, the directive principles contain the social, economic, cultural and educational objectives of the state. These provides a motivation for a peaceful political revolution. These also provide a program for social reconstruction and economic upliftment of the people of India. The directive principles inscribe the ideas and aspirations of the people of India for which they had fought against the foreign rule. Now, let us talk about the relationship between the fundamental rights and the directive principles of state policy. In any democratic country, constitutional law and governance are fundamentally shaped by the interplay between fundamental rights and the guiding principles of state policy. Despite their differences, these two ideas are interconnected and supportive of one another in the larger goal of attaining social justice and making sure that society is just and equal. The directive principles and the fundamental rights are mutually reinforcing in their relationship. While the fundamental rights outline the protections that people should have to ensure their rights are upheld, the directive principles, on the other hand, outline the objectives that the Indian state should pursue. Together, they create a framework that safeguards Indian people's individuals' goals. These two ideas are related because they both aim to create a society that is fair and just. The goals of both fundamental rights and directive principles are to safeguard the social fairness and to protect and advance individual well-being. While the directive principles instruct the state in creating policies that advance the greater objective of a just society, at the same time, the fundamental rights give the individuals a legal protection against any infringement of their rights. Additionally, the application of directive principles and the fundamental rights is linked and dependent upon each other. The judiciary is essential to this relationship because it interprets and protects the fundamental rights while taking the directive principles into account. The directive principles have been used to uphold the constitutional validity of the legislations in case of a conflict with the fundamental rights. Article 31C, added by 25th Amendment in 1971, provided that any law made to give effect to the directive principles in Article 39B or C would not be invalid on the grounds that they derogated the fundamental rights conferred by Article 14, Article 19 and Article 31. The application of this article was sought to be extended to all the directive principles by the 42nd Amendment in 1976, but the same was struck down by the Supreme Court on the ground that it violated the basic structure of the Constitution. The fundamental rights and the directive principles have also been used together in forming the basis of legislation for social welfare. The Supreme Court, after the judgment in the very landmark case, that is Keshwant Bharti case, has adopted the view of the fundamental rights and directive principles being complementary to each other, each supplementing the other's role, which aims at the same goal of establishing a welfare state by means of social revolution. Now, there are different case laws that we will be discussing. The place the directive principles occupy in the Constitution vis-a-vis the fundamental rights has been a subject matter of a controversy for a long time. The controversy has now been set at rest by the Supreme Court in the case of State of Madras versus Champakam Durai Rajan, AIR 1951, Supreme Court, page 228. And the Supreme Court held that the directive principles cannot override the fundamental rights. The directive principles have to conform and to run as a subsidiary and parallel to the fundamental rights. In the reference case of Kerala Education Bill, AIR 1957, Supreme Court 956, the court observed that though the directive principles cannot override the fundamental rights, nevertheless, in determining the scope and ambit of the rights, the court may not entirely ignore the directives, but should adopt the principle of harmonious construction and should attempt to give effect to both as much as possible. 42nd Amendment 1976 widened the scope of Article 31C so as to cover all the directive principles. Thus, it gave precedence to all the directives over the fundamental rights articles, that is 14, 19 and 31. In the case Narendra Bharti versus State of Kerala, AIR 1978, Supreme Court, page 1461, the court observed that the fundamental rights and directive principles are meant to supplement one another. It can well be said that the directives prescribe the goal to be attained and the fundamental rights lay down the means by which that goal is to be achieved. Both are equally fundamental, though directives are not directly enforceable by the courts. In the case of Minerva Mills versus Union of India, AIR 1980, Supreme Court, page 1789, the court struck down Article 31C as amended by 42nd Amendment as unconstitutional on the ground that it destroys the basic feature of the Indian Constitution. The court held that the unamended Article 31C is valid as it does not destroy the basic structure of the Constitution. Article 39, Clause B and Clause C are vital for the welfare of people and does not violate Article 14 and 19. Other directive principles could not override the fundamental rights. But in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited, 1983, the Supreme Court expressed the doubt on the validity of its decision in Minerva Mills case. It held that amended Article 31C is valid. The extension of constitutional immunity to other directives does not destroy the basic structure of the Constitution. Finally, in the state of Tamil Nadu versus Abu Kabur Bai, AIR 1984, Supreme Court 626, it was held that although the directive principles of state policy are not enforceable, yet the court should make a real attempt at harmonizing and reconciling the directives and the fundamental rights, and any collision between the two should be avoided as far as possible. In another case of Unikrishnan versus State of AP, 1993, Supreme Court, page 1645, the court has reiterated the same principle that the fundamental rights and the directive principles are supplementary and complementary to each other, and the provisions in Part 3 should be interpreted having regard to the preamble and the directive principles of state policy. Now, let us talk over the difference between directive principles of state policy and fundamental rights. First point of difference: while the fundamental rights constitute limitations upon state action, the directive principles are in the nature of instruments of instruction to the government of the day to do certain things and to achieve certain goals by their actions. Number 2, fundamental rights are justifiable and directive principles are non-justiciable. One can approach the courts, even the apex court, for the enforcement of fundamental rights, whereas one cannot approach the courts for the implementation of the directive principles. Number 3, the directive principles, however, require to be implemented by legislation And so long as there is no law carrying out the policy laid down in a directive, neither the state nor the individual can violate any existing law or legal right under the color of following directives. Difference number 4. The fundamental rights lay down the negative obligations of the states. Directive principles are, on the contrary, affirmative directions dealing with the positive obligations of the state towards the citizens. They declare the duty of the state to promote certain social and economic objectives. Point number 5. The main objective of fundamental right is to establish political democracy by guaranteeing the equality, liberty, religious freedoms and cultural rights, etc. But on the other side, the aim of directive principles of state policy is to establish just social, economic and political order. Now let us conclude the topic. Therefore, we can say that there is no conflict or disharmony between the directive principles and the fundamental rights, because they supplement each other in aiming at the same goal of bringing about social revolution and establishment of a welfare state. The objective of both is securing social, economic and political justice and dignity and welfare of the individual. Both are on the same level, same track. In case of an apparent conflict, it is for the courts to resolve it in exercise of its power of judicial review. The establishment of a just and equitable society depends on the interaction between the fundamental rights and the directive principles of state policy. The directive principles of state policy steer the state in advancing the social welfare and achieving social fairness, whereas the fundamental rights safeguard and protect the individual liberties. Their interaction is very crucial to developing a harmonious and well balanced legal system that respects the democracy and our human rights. Thank you everyone for your time and attention. I appreciate this opportunity to speak with you today. I hope you have understood the lecture and enjoyed it. Stay safe, stay healthy. God bless you all. Take care.